for those technical difficulties. Thank you again for joining us this morning for this webinar where we're going to go over navigating and implementing the new Title IX rules. And we're really going to focus on strategies for K-12 school districts and specifically focused more so on student Title IX matters. My name is Nina Gupta. I'm also joined by my partner, Suzann Wilcox. We are partners here in the education team at Nelson Mullins in the Atlanta office, where we devote our practice entirely to representing educational institutions, including public school districts of every size imaginable. As we go through this presentation, there's a lot of information to cover, but if you have questions as we go through, please go ahead and put your questions into the questions pane. If you have time at the end to answer them, we will collect them and we can send out responses to the attendee group at the end. And we have a lot of information to cover, so let's just get right to it. So a couple of months ago, the United States Department of Education completely overhauled Title IX. And in doing so, they drafted some new regulatory provisions affecting Title IX, including changing the definition of sexual harassment and what is covered in Title IX. They have significantly changed how schools need to respond to sexual harassment generally and how they respond to formal complaints as well. In doing so, they drafted new regulatory provisions and also made some amendments to existing regulations as well. So let's first start with a school district's general response to sexual harassment. The regulations say that a recipient, and that's the school district, with actual knowledge of sexual harassment in an education program or activity against a person in the United States must respond promptly and in a manner that's not deliberately indifferent. So let's go through those three jurisdictional requirements. First, misconduct has to be sexual harassment, and we're going to go over the definition of that. That's in the regs. The misconduct has to occur in an education program or activity. So any off-campus sexual misconduct that happens outside of a program that you offer is no longer within the jurisdiction of Title IX, and you do not have to treat it as a Title IX matter. So a sexual assault that may happen in a home during a break is no longer subject to the Title IX process. Now, it might be subject to your code of conduct generally, but you can use your usual code of conduct and student disciplinary procedures to address it. Additionally, the misconduct has to occur in the United States. So if you operate foreign exchange programs, or if you have overseas field trips, anything that happens overseas during those programs, even though they are programs that you sponsor, would not constitute sexual harassment subject to Title IX's provisions. So one thing to remember, additionally, we talked about actual knowledge here. There's a neat little quirk in the regs that state for public K-12 school districts, actual knowledge means knowledge by any employee of the public school district. So that includes much more than your administrators or teachers, etc. It's any employee. And like we said, we're limited, at least in our jurisdiction, in that the conduct itself has to happen during school or at a school program, and it's got to happen in the United States.
And this is Suzann Wilcox chiming in. And I just want to go over the categories of the misconduct that's going to meet the definition of sexual harassment. And this is different. So if you are used to the old definition of Title IX, this is going to be definitely a change for you. There's really three main categories here. One is going to be your standard quid pro quo. Generally, that's going to happen in an employee situation, but it could happen in a student situation. And of course, that's what we're focusing on here today. Essentially, this is an unwelcome aid or benefit being conditioned on some sort of sexual conduct, and it's going to be looked at based on the circumstances. So if there's an power differential between like a professor and a student or a teacher and a student about a grade, that could be a situation where it might apply to a student. And then the next category is sexual assault. And this has specific definitions that are in the Clery Act and VAWA. And essentially, it's going to be types of physical sexual assault. But when you start looking at domestic violence and stalking, that may not include any kind of physical at school type behavior. You will have to look at those definitions. And we're not going to get too deep into those specific definitions. That's really almost another webinar. But we will be talking about how you would manage these. I do recommend, however, that you get deep into that. If you don't have an attorney that works with you, that's something that we could help you with. But those are highly technical definitions, and you may need to include those in your code of conduct. So definitely be familiar with number 2. And then number 3 is a catch-all. It has to be so severe, pervasive, and objectively offensive that it has a systemic effect of denying access to programs and activities. And this is a standard borrowed from the elements of a student-on-student sexual harassment claim under Davis, which is kind of the quintessential case that we look to in this. If you're not familiar with that, we'll kind of walk you through the elements of what this is going to look like under Title IX anyway. But for the misconduct in this category, it has to meet all of these requirements. That is a high standard, and it's a lot of student misconduct that we traditionally consider to be sexual harassment is not going to fall into this anymore. When you talk about effectively denying a person access to a program or activity, you're not talking about these one-off verbal harassments. That doesn't mean verbal harassment couldn't meet the standard, but a one-off type situation is not going to meet there. So looking at this through a new lens is going to be an adjustment for a lot of our folks.
And that's not to say that verbal harassment, you are powerless to address it.
Right.
All this means is that you don't have to address that kind of behavior through the Title IX process, which, as we're going to find out, is unwieldy and complex. You can still address that behavior through your code of conduct. Also, Suzann mentioned a couple of other statutes that provide us definitions for dating violence, domestic violence, and stalking. Those statutes are the Clery Act. And Suzann also referenced VAWA, which stands for the Violence Against Women's Act. The citations to those statutes are here on this slide as well. So if you want to go look them up, you can. They're pretty easy to find.
There you go. So let's talk about actual knowledge. We know that's an important part of what sexual harassment is going to be under our new Title IX regulations, but what does that actually mean? For instance, here's some hypotheticals for you. A custodian who overhears 2 students bragging about sexually assaulting a student in a school closet, or a teacher witnessing a student sexual assault. And is that going to be a situation of actual knowledge? Well, in the past, you really had to have either the Title IX coordinator had to be actually aware of it, or you had to have somebody in the organization who was high enough up that could institute corrective measures. And a lot of times that would be a school administrator, someone who could actually take action, not a bus driver or a custodian or something like that. But now Title IX's new regs makes it very clear that it is any employee of an elementary or secondary school. That is huge. That's a huge change for us. So that's going to be your administrators, teaching staff, your clerical staff, your secretaries, and your custodian and food service staff. So that is going to be something you really are going to have to manage. That means you're going to have to do a lot of extra training. So going back to the hypotheticals, a custodian who overhears it, we're going to have to find a way within your organization to make sure that gets to the Title IX coordinator. And you're going to have to set up an organization-specific process to make sure those lower level employees, those hourly employees or lower level employees, are going to have a way to get that up the chain to the right person to handle it, because you're going to be held liable if they don't. The other aspect we have to keep an eye on is not exhibiting deliberate indifference. And what is deliberate indifference? Well, anything that would be clearly unreasonable as far as a reaction in light of the known circumstances. Of course, not reporting it. That would be deliberately indifferent because you didn't do anything with the information. And although we aren't really sure at this point what deliberate indifference is going to look like under these, I would say also not following your grievance process would also be considered a deliberate indifference. What I think is not going to get you in that category is if you handle it through the grievance process and you come out with a decision that maybe someone wanted to second guess and say, well, I would have done something else. That's not deliberate indifference. Just failing to follow your processes we believe would be. And one thing you have to make sure happens, whether there is a formal complaint or not, is to make sure there's supportive measures. And part of that is understanding who are your people that you're giving supportive measures to. These regs use new language, new terminologies. It's not perpetrator and victim. It's not plaintiff and defendant. One of the ways they've changed this is to switch up our verbal use of this. Complainant is going to be the person who is alleged to be the victim of a conduct that could be sexual harassment. So we really need to start getting it in your head that you're going to need to use complainant instead of victim. That isn't always the person that reports it, okay? This is the person that is potentially subject to the sexual harassment. Any person could be in a complainant, but when we're talking in this webinar, we're really talking about students in those situations. So just remember that when we say complainant, we're really talking about the victim. And again, this is a terminology shift in your mind.
One thing that the new Title IX regs make very, very clear is a school district's responsibility and obligation to implement supportive measures for both the complainant and the respondent. The respondent is the alleged perpetrator, for lack of a better word, when there is alleged sexual harassment to have occurred. So a recipient's response must treat complainants and respondents equitably by offering supportive measures to a complainant. You just heard the definition of complainant. That's the person who is alleged to be the victim of potential sexual harassment. Now, importantly, supportive measures must be non-disciplinary and non-punitive individualized services offered to both parties that are made available without fee or charge to either party before or after the filing of a formal complaint, or even when no formal complaint has been filed. So let's break that down.
That's a lot.
You don't need to have an actual complaint. What you need to have is knowledge that there may have been sexual misconduct. And that is your trigger to start instituting and implementing supportive measures that are supposed to be free for everyone and non-disciplinary. So it is not a supportive measure to say, respondent, you don't get to come to school anymore. That sure looks disciplinary, it looks punitive. The regs make clear, and the commentary to the regs make clear, that the supportive measures that you're going to be implementing are designed to preserve equal access to your educational programs or activities without unreasonably burdening either party. And they're also designed to promote the safety of parties and deter sexual harassment, but again, non-disciplinary. Now, the regs do include a list of things that may constitute supportive measures. You see the list in front of you. It is not an exhaustive list, of course. You are limited only by the creativity of your own imaginations and your own expertise. The only guardrails that you have is you need to make sure that they're free, they're non-disciplinary, they're non-punitive, and they're designed to essentially preserve the status quo and safety of allowing both parties equal access to your educational programs.
What I thought was interesting when these regs were issued, they came with a 2,000-page guidance document, which is very meaty and kind of scary. And one thing they have in there is the regulatory impact, and it talks about the cost, what they think, what the USDOE thinks is, or OCR thinks is the cost of these. And they estimated the cost to be $250 per supportive measure. I don't know where they got that from. I think that's a gross under calculation, but there you go. If you want to try to figure that out, that's one option to look at.
I will suggest that, you know, the DOE in their 2,000 pages of commentary do offer estimates of how long each step should take of this grievance process and how many hours it should take. And if they are accurate in those estimations, I will be pleasantly surprised. I think they are somewhat optimistic.
They were, yeah, I would agree with that.
So, continuing on with our supportive measures, your Title IX coordinator is going to have some responsibilities here. The Title IX coordinator, upon receiving a report or complaint of sexual harassment, now needs to have some detailed discussions with the complainant about available supportive measures, what the complainant's wishes are with respect to those supporters, and the process for filing a complaint. So this can't just be an on-paper process, complainant files a complaint and there you go. The Title IX coordinator is going to have need to have some training, some expertise, and the right kind of sensitivity and discretion to have those kinds of relatively difficult conversations. Now, school districts of various sizes may find that the Title IX coordinator's job may be too big for just one person. So you may need to have more than one coordinator in your district, depending on your district's size and needs. Some potential models that you might want to consider is that there are school-specific Title IX coordinators or high school cluster-specific Title IX coordinators that report up to regional Title IX coordinators, who then report up to the district-level primary Title IX coordinator. You may be able to pull off a single Title IX coordinator model. You may want to have sort of a sub-coordinator for student complaints and a sub-coordinator for employee complaints that report it to a district level single coordinator or any combination thereof. What will be important for you that as you are making these decisions to serve as your guide is an estimate of how much work this really is and how much time these coordinators are really going to have to spend and what their other job duties are, so you can decide how to best share the load.
And something Nina and I are working on for our clients is a checklist of what we think this is going to entail, this job's going to entail. And I really think it's a good investment for those of you that don't regularly work with attorneys. You're going to hear this theme throughout our presentation, but you're going to need to engage experts on this, at least setting up your framework, if not helping you get through the first year or so of day-to-day. Our team is very experienced with that. It's actually pretty cost effective to do this all on the front end and not wait to get sued or find yourself in a situation where you're too late to the party. So we would encourage you to get a professional to help you set up your process, set up your policies, and we would be very happy to help you with that. So just a thought there.
And one thing I want to piggyback onto that is I would be leery of a generic process that doesn't take into account your school district's particular needs and your school district's particular culture and your school district's existing administrative structure. Anyone can go read these regulations and, you know, just kind of want to curl up into a little ball with how much it is. But what you need is help breaking it down so it works for you and it works for your students and your legally compliant.
It is not a one size fits all, not in any stretch.
So now let's get to this grievance process. And this may curl your hair if it's not curled already. The Title IX regulations state that a recipient's response must treat complainants and respondents, that's victim, perpetrator, alleged, equitably by following a grievance process that complies with this federal regulation that they've drafted before the imposition of any disciplinary sanctions or other actions that are not supportive measures. So let me emphasize that. You cannot impose any disciplinary sanction or take any other action against an alleged perpetrator until you have completed your grievance process. The only thing you can do pending the completion of that grievance process is institute supportive measures that are non-disciplinary and non-punitive.
Plus, there's an emergency removal process that we'll go over, but the standard for that is fairly high. So really, you need to start getting your head around the fact that this is not a let me put you out and we'll ask questions later type situation. Those days are done when we're talking about alleged sexual harassment. And just to go back to terminology, I just want to remind you, not only do we have a new word for victim, we have a new word for the perpetrator. Now we're going to be calling them respondents. And you can tell they're really trying to take the blame out of the process prior to a determination. So this is a person who's been reported to be the perpetrator of conduct that could constitute sexual harassment. So again, that's just a terminology shift for you. Going into the formal complaint process, once we get a formal complaint, you as a recipient must follow a grievance process that complies with the statute, or excuse me, the regulatory compliance. And those are found in 106.45. Even if you don't have a formal complaint, if there is a potential that reported behavior meets the standards of sexual harassment under these new regs, you still have to offer supportive measures. So even when there is no formal complaint filed, you still have to go through that supportive measures calculation and really looking at that on a one-off basis to see what we need to do. And I will tell you, this is going to require a lot of training on the part of your staff, because I think a lot of our staff are used to saying, well, if there was no complaint, they didn't file a formal complaint, so we don't really have to do anything. That is no longer the case. And also we recommend that even if a complainant doesn't come forward and say, I want to file a formal complaint, you may be in a situation where we know so much, or we're so sure that this is a sexual harassment situation, that the Title IX coordinator actually is going to file the complaint on behalf of the complainant. That's a kind of an advanced move. I don't want to get too deep into that, but just keep in mind that just because they don't file a complaint doesn't mean that you don't have to do something. This just talks about what a formal complaint is. I'm not going to spend a lot of time. I will say that at the time the complainant has to be either participating or attempting to participate in the program. So it can't be someone who's left the program. There are some jurisdictional standards there. And that's something that you have to keep an eye out, because there are some requirements of who you can be. There's lots of ways they can file it. I think this kind of speaks for itself. I won't spend a ton of time on that. We do recommend that you come up with some sort of form process for folks to be able to file that. And again, that's a good place for a professional like our office or your board attorney to help you out. Emergency removal. This is really your only option for getting a student out of the school prior to the completion of the appeal. Not just the formal grievance process, the appeal has to be done. Either they haven't taken the appeal or they have lost the appeal, quote, quote, the respondent has. So this is your tool. These have to be a situation where the student is an immediate threat. So that means you have to do an individualized safety and risk analysis, and you have to give them notice and opportunity to challenge the decision immediately following the removal. So you remove the student, you still have to give them some sort of due process or some sort of way to give their side of the story, a real way to give their side of the story. And it can't look like discipline, of course. So this has to be a very non-disciplinary process. I would consider, even though we don't want to make it a discipline process, I would consider to go to the kind of your GOSS process for notice and opportunity to be heard, where you give them a chance to tell their side of the story. It can be informal. It doesn't have to involve attorneys. We wouldn't recommend a hearing process. It would really, truly just be an opportunity. And if they don't want the opportunity and you give them an opportunity, I would say it's done. So again, I think this is a place where you need to have a process in place, and you're going to need a professional to help you set that up. Remember that an emergency removal is going to be subject to IDA. It's going to be subject to Section 504 and ADA. That means you may, if it's a change of placement, if a removal is a change of placement, you may have to have a manifestation determination for that, even though it's not discipline. And you may also have a stay put if they were to file a hearing. So that means in order to get that student out where there's a hearing filed, you may have to go through what we call a honing injunction. That is a whole nother webinar. Just know that there are some complicated intersections. And again, you're going to need legal professionals to assist you with making that determination. We're not really touching on employees in this process, but just note that we can place employees on administrative leave during the formal grievance process. But again, you have to take into account their ADA rights. So just keep that in mind. We're not spending really any time on the employee process here today. Again, that's a whole separate webinar, and look for that probably coming soon. But just know that that is an option for you. And remember, you have to, oh, sorry, Nina, go ahead.
One other thing you'll want to remember with your employee leave and administrative leave is it's going to be subject to any collective bargaining agreements that you may have, any contracts of employment that you may have as well. So be careful that you're not running afoul of those.
Yeah, and again, that's a whole juicy topic that we'll have to dive in with you at another time.
The one really important evolution in the Title IX regulations is this very strong and explicit prohibition against retaliation. What this reg says is that we cannot take any action to intimidate, threaten, coerce, discriminate against any individual for the purpose of interfering with their rights secured by Title IX, and that includes testifying, participating in a process, or refusing to participate in a Title IX process as well. So the key concepts for all of us to keep in mind here is that this regulation prohibits retaliation by the school or by any person. Retaliation has a pretty broad definition, and it covers every part of the grievance process, every part of the Title IX process. For instance, if you choose to have a live hearing process as part of your Title IX grievance and your complainant refuses to testify, thereby making it difficult for you to impose discipline, you cannot terminate supportive measures being provided. You also cannot use your general code of conduct to circumvent a respondent's procedural rights under the formal grievance process. So you can't be clever and say, well, it's a sexual assault, but it's also an assault and battery, which can be disciplined under our code of conduct. So we're going to use our student disciplinary procedure. You can't do that. You must follow your Title IX grievance procedure. You cannot separate them out into other non-Title IX behavior in an attempt to get around that grievance.
Trust me, we thought that was the first thing we thought of, and when we looked deeper, we realized that was not an option.
Now, there are a couple of exceptions to this retaliation provision. The exercise of rights protected under the First Amendment does not constitute retaliation. That's an interesting sort of addition to this regulation. Additionally, making materially false statements and taking action against an individual for making those materially false statements does not constitute retaliation. Now, this is a murky area when you're looking at exceptions to retaliation, especially when you're talking about anything involving the First Amendment or constitutional rights. We're certainly happy to help you navigate those murky waters, but it gets complicated fast. So if you need help, ask for help.
Good advice through this whole process.
So the regs additionally also state that a recipient's treatment of a complainant or a respondent in response to a formal complaint of sexual harassment can in itself constitute sex discrimination under Title IX. Here's what they're trying to say.
In terrible words.
What they're trying to say is that if you don't follow the right regulatory process, that deviation from the correct regulatory process is itself potentially a violation of Title IX. This just underscores how important it is to build out your process, make sure you know it, and make sure you implement it with fidelity. So as we get through the grievance process, any grievance process that you have has got to comply with the federal regulations, and any provisions and rules or practices that you have as part of that grievance process need to apply equally to both parties. That's a really important concept that you've got to keep in mind throughout Title IX. There's, like Suzann said earlier, very much an emphasis on avoiding any presumption of guilt or innocence, quite frankly, although more so presumption of guilt. And that's why the regulations seem to place a real center of gravity towards putting both parties on equal footing until the evidence shows otherwise.
And this one just talks about what some of the core processes are. And one thing that we found interesting is it really also focuses on equity and treating complainants until the time that one party is exonerated or found to be quote, quote, guilty, treating them equitably and giving them as identical rights as possible during that process. So, and before we can do anything that is a disciplinary sanction, we have to go through the process and get through this grievance process first. Your investigator is going to need to do the decision maker in these process is going to have to do an objective evaluation of all relevant evidence, including inculpatory and exculpatory. So things that prove guilt and things that prove innocence. They have to look at all of the evidence available. And it cannot be a situation where we put more weight on a statement by a victim or we put more weight on a statement by the complainant, or excuse me, the respondent or a witness. So you can't give any weight based on what role they play in the whole situation. So I thought that was those are kind of interesting standards that probably you already knew inherently, but they're being brought really to the forefront of your mind. And Title IX coordinator, the investigator, the decision maker, or any person who's going to facilitate an informal resolution process, which we'll talk about in a bit, cannot have an interest, a conflict of interest, or a bias, either for or against complainants. And actually, you'll see as we go through, when we get to the end of the process, if someone wants to appeal, alleging a bias is one thing that you can appeal based on. Either party, the victim, quote, or the perpetrator, quote, which we know are now the complainant and the respondent. That is a basis for appeal. So you want to make sure that the person that you're selecting is going to have no perceived bias and no actual bias. And sometimes perception is reality in these situations. So make sure you're giving some thought to who you're assigning to those roles. The grievance process has so many requirements that even if it didn't specify training, you would need to do training. But the law specifically, or the regulations specifically, outline what training is required. So definition of sexual harassment, the scope of the jurisdiction, obviously the grievance procedure, and all the way from beginning to end, how to be impartial, and then your decision makers, or if you want to call them your hearing officers, but not necessarily, we'll talk more about that in a little bit, have to have training on live hearing technology, because there is a requirement that the parties can ask to be in a separate room, but also have real time. So you'll have to have training on that, and determining the relevance of evidence and questions, how to handle prior sexual behavior, and then of course, how to investigate, how to train on issues of relevance, and how to make an investigative file. So really how we've broken it up in our mind is three main buckets of folks that need training. Those are your Title IX coordinators, however many you decide to have. Those are your investigators, and then your decision makers / appellate decision makers. Those folks all need their own special training, and then they all need to understand the full process so that they understand their role in the process. This is a lot of work. This is a big lift. This training needs to be in place before these regs take effect, which is in August, because you're not already busy enough with dealing with coronavirus and all the other issues that you've got going on. So you are going to need some professional help. Our team, this is something that we do every day. We have trainings that we're already preparing. We are ready to go, boots on the ground with this. So if you need assistance with getting this training, please let us know. And again, we do recommend that the training not be one size fits all, that it be tailored to your organization and your process. Anything you want to add about the training process, Nina?
One thing that I want to stress is that your investigators and decision makers and Title IX coordinators are going to have a level of legal knowledge and facility with legal concepts that are really kind of complex, and that lawyers get wrong at times. So please don't skimp on the training. By the way, your training materials are going to need to be publicly available as well. So you're going to want to make sure that they are up to snuff, that they are both inspiring confidence in a public-facing kind of way, but also achieve their objective in actually imparting the knowledge that you need your investigators, decision makers, coordinators to really have to implement a process with fidelity.
That's right. Your training materials are going to have to be neutral. Not only is your process neutral, but your training materials are going to have to be neutral. And that is something that you are going to need, again, somebody to look at from an outsider's perspective and make sure is the case, because there may be things that you don't pick up on in your training that actually are problematic. So please make sure that you're having somebody with the right set of skills look at your trainings, even if you decide to do them in-house, and make sure that they're correct, and make sure that they are not somehow biased one way or the other. Again, we're getting back to this, they're presumed not responsible until a determination is made. And this goes all the way through the appellate process. So if they appeal, they are still deemed not responsible. So let's say you have a student who is found to be, quote, guilty of sexual harassment. They are not responsible. That student is not responsible until the appeal is finished, or until they elect not to pursue appeal and the timeline expires. So again, we're going to keep that presumption of innocence all the way through.
Your grievance procedure is also going to need to be published, and it's going to need to include some pretty basic requirements. One of those requirements is that you have to have some reasonably prompt timeframes for conclusion of the entire grievance process, including informal resolution process and appeals. Now, it used to be, before these regs came out, that there was a 60-day deadline to resolve Title IX grievances. That deadline is now gone. You can choose for yourself how long you believe reasonably prompt is, but just make sure it's reasonably prompt. You also need to have a process that allows for a temporary delay of the grievance process or a limited extension for good cause, provided that you provide written notice to the parties of that extension or delay. And this is new. Good cause can include considerations like absence of a party or a party's advisor or a witness. It can also be for concurrent law enforcement activity. It used to be that we had to follow our Title IX grievance procedure and get to a determination of guilt or innocence, even though we knew that there was a law enforcement investigation happening and we stepped all over it. Now we can hit pause on our own Title IX grievance procedure so law enforcement activity can do its thing as well. The only requirement that we need to make sure that we meet is that we provide notice to the party that this is a possibility, and when we implement those delays or extensions, we provide written notice to the parties there as well.
And something I didn't mention during the training conversation, and what you said just triggered that with me, is actually your training has to be published. Not only does your grievance process have to be published, your training has to be published. That's another reason why you need your training to be tip-top, because it is going to be inspected by advocates, by other attorneys. You need that training to be right and to be neutral.
Another facet of your grievance process is going to be describing the range of potentially available disciplinary sanctions and remedies. This is going to be soup to nuts, everything that you might do, starting with a restorative circle to permanent expulsion and everything in between, because we all know that the levels of sexual misconduct that are available may warrant something as severe as permanent expulsion. You also need to decide on a uniform standard of evidence, and you've got to choose between two options. You can use a preponderance of the evidence, which many school districts are already used to using in their student disciplinary hearings. Colloquially, it's kind of referred to as 50% plus a feather, or a higher standard known as the clear and convincing evidence standard. That's a more exacting standard. The only thing to keep in mind is that you've got to choose one standard and apply it to all complaints involving both students and employees. And this is where, if you have collective bargaining agreements or employment contracts that state that employees are entitled to some sort of due process, and they need to, and the burden is on the school district to present evidence to a clear and convincing standard, that standard is already baked in the cake for you. Because if you're using that for employees pursuant to a CBA, pursuant to an employment contract, for Title IX matters involving employees, you now have to use that same standard for Title IX matters involving students, even if every student disciplinary matter in every other context is subject to a lower preponderance of evidence standard. So keep that in mind. Additionally, your published grievance procedure needs to include procedures and permissible bases for parties to appeal. Title IX does require an appellate process, but it leaves the details of that appellate process up to recipients. We're going to get to that in a minute. And we've also got to describe the range of supportive measures available to the parties. That list that we covered earlier that is in the regulations, that's a good start. But as I said, you are limited only by the creativity of your own imagination and expertise. So you may just want to have a catch-all for other supportive measures as appropriate to the situation.
Yeah, definitely. I would have a generalized statement in there too.
Mm-hmm. Additionally, your grievance process needs to have a standard that says that it does not allow evidence or questions that would invade a legally recognized privilege unless the privilege holder waives it. That is a very legalistic concept that your investigators and decision makers are going to have to be able to navigate. That can present a very thorny legal issue, and the US DOE has not provided a lot of guidance on this. The regulatory commentary, that 2,000 plus pages, has less than a page on this issue and gives only cursory treatment to the issue. Privilege varies by jurisdiction depending on what state you're in. It varies depending on the nature of the privilege, attorney-client, psychotherapist, priest-penitent. We can certainly help you design and implement training practices to help you resolve these types of issues that are specific to your state and your state's legally recognized privileges.
One thing that's going to be familiar to you probably in this process is that you have to provide some sort of written allegation. But what's interesting about that allegation is it has to be for both parties. And again, FERPA is not preventing you from sending these out. So it's going to have to go to both the respondent and the complainant. And it's going to have certain things here, the allegations, the procedures, and any code of conduct provisions that apply. So this is a great place for a form letter. This is a great place, again, for someone to help you automate as much of this process. It's not a lot that we can automate, but automate as much of this process as possible so that you don't have folks making up their own letters on the fly. That's one of the recommendations that I would make. Please note there are requirements for dismissal. Okay, so there's a permissive dismissal and then there's a mandatory dismissal. If it doesn't meet the jurisdiction of a Title IX complaint, which we've already gone over, then it has to be dismissed. The Title IX coordinator must dismiss it. There are some permissive dismissal abilities as well. If someone wants to withdraw it, if they aren't enrolled anymore, if they're not employed anymore, or if there's some sort of circumstances that prevent you from being able to gather evidence, that is going to be very fact specific. But either way, if it's mandatory or permissive, number one, it's subject to appeal. And number two, you have to give notice to both parties that it's been dismissed. And again, that's a place where you're going to want some sort of form process that you've had some assistance and created by a professional. As far as the burden to investigate, that must remain on you. You can't say to the complainant or the respondent, you go get whatever witness statements you want and I'll look at them. We have to interview. We have to follow up with those leads. That's something that the school district is going to have to do. And obviously, either party can suggest evidence, and we would recommend you follow those down. You also can't say, oh, don't put anything on social media, don't talk to anybody about this, it's confidential. You can certainly suggest that, and I think it's probably wise to suggest that people don't go up and talk about it, but we can't impose any kind of gag order. I don't know that you would really try to do that, but I know at times we've asked folks to keep these things quiet, but you really can't enforce anything like that.
Additionally, both parties have the same right to have others present during the grievance process, including an advisor of their choice who can be an attorney. So the days of questioning a student who asks for his mom or dad to be present, or who asks for his lawyer to be present, those days are over. We cannot limit the choice or presence of an advisor. All we can do is establish restrictions on the extent to which they can participate, provided that they apply equally. So we can allow them to be in the room, but we can allow them, but we can require them to stay silent and be silent observers only.
And that is only for these Title IX type situations. You may still do that in your regular disciplinary process, but in these Title IX type situations, you're going to have to modify your practice and allow these folks to be present.
Additionally, you will be obliged to provide to the party whose participation is invited or expected written notice of the date, time, location, participants, and purpose of all hearings. Essentially, you've got to, it's like a little mini notice all throughout your grievance process. You've also got to allow both parties an equal opportunity to inspect and review any evidence that's obtained as part of an investigation that's directly related to the allegation. And this is a right that they need to know about in advance. So that means, I mean, let's think about that. If medical records are part of the evidence, the other party gets to see them, and that can be very sensitive information, and the regs don't really concern themselves with that very much. Both parties get to see all of the evidence. Additionally, before the completion of the investigative report, you've got to send all of the evidence to the parties and their advisors and give them 10 days to submit a written response. And then your investigator needs to consider that written response before completing the final report. And then you finally get to your final investigative report that fairly summarizes relevant evidence. It is factual only. No conclusions, no recommendations. It is dry as dust, just the facts, almost like a police report. And at least 10 days before a hearing, if you decide to go with a live hearing, you've got to provide the parties and their advisors a copy of the final investigative report for their written review and response.
And it's really important, again, that you have forms for these things. That's going to help your staff do a uniform job on these.
Now, we've referenced the live hearing for post-secondary institutions, colleges, and universities. Their grievance process must provide for a live hearing. For K-12 public schools and other K-12 recipients who are subject to Title IX, you can choose to have a live hearing if you want to, but you don't have to. Now, with a hearing, understand that the live hearing can be adjudicated. This is going to be your decision maker by one or more decision makers, so you can have a panel. But the decision maker cannot be the same person as the investigator or the Title IX coordinator. So you have now just introduced a third individual into the process.
Didn't have enough to think about. Another decision you have to make is whether or not you're going to have a live hearing. Again, for you at the K-12 level, it's optional. You don't have to do it. If you have a live hearing, cross-examination must be allowed. And here's a disadvantage that we've noted of having these live hearings is that we have to have cross-examination. That shouldn't be anything new if you have disciplinary hearings that happen. But in these situations, the cross-examination must occur directly, orally, in real time by the party's advisor and never by a party personally. There's a lot in there. Directly, orally, in real time means that you may have to have technology if they want to be in a separate room, because it has to be in real time and it cannot be on paper. And then also you have to have an advisor appointed so that they can cross-examine, because the party can never cross-examine anyone directly. So that means you're going to have to find someone who serves as their advisor if they do not provide their own. And it cannot be something they pay for, and it has to be of the recipient's choice. So what we've imagined for something like this is coming up with a pool of folks that are willing to volunteer their time. So if you can imagine using law students, college students, maybe retirees that are volunteers in your school district, but they have to be trained, and you're going to need to have a variety of language speakers available potentially. Ideally, you're going to have some pool folks that can speak the language of the student. Now, you can always provide interpreters, but that's going to be very awkward. So just think about, how are you going to provide these advisors? This may be a reason that you don't want to have a live hearing if you can avoid it.
And keep in mind that those advisors need to be equally available. So you don't have a pool of advisors for complainants and a pool of advisors for respondents. You have a pool of advisors that are equally available to everyone.
And so those folks are going to have to agree to be available either way. Remember that only relevant cross-examination, other questions have to be made. So your decision makers have to be trained to screen for relevance in real time. It used to be that we could just wait for objections. You can't do that. Now your decision makers, or your hearing officers, however you want to call them, are going to have to be able to determine just from hearing it whether or not it is relevant. And also they have to be trained on knowing which questions are not allowed, including rape shield questions. Cannot be allowed unless they go to whether or not the question would exonerate this particular person. For instance, it wasn't me, it was someone else. You have our identities mixed up. Or if they would say, well, it was consensual because we were actually dating at the time, or we had some sort of history and I want to present that. Those are the only times that prior sexual activity can be brought in. You have to have training, all of these things, and you can see how that could be daunting.
Additionally, if you choose to have a live hearing, no hearsay evidence is allowed. So if a party or a witness does not submit to cross-examination at your live hearing, no out-of-hearing statement from that party or witness is admissible. So for instance, if a respondent confesses to a sexual assault during your investigative process, but refuses to submit to cross-examination in the hearing, that admission in your investigative process is not available to your decision maker. If there are medical records that indicate that a sexual assault occurred, but the lab tech or medical examiner is unknown or not available to testify, it's possible that those medical records can't be admissible or considered. There may be a text string between the complainant and the respondent that show guilt or show innocence, either way. But if the respondent refuses to submit to cross-examination, that text string is not available to the decision maker. That's a heavy burden, and that's a heavy lift.
And that's a heavy training lift. So again, you're going to need professionals to train your decision makers.
Additionally, if you do decide to have a live hearing, you've got to be prepared for virtual hearings as well, even outside of this COVID context, because at the request of either party, the school district needs to provide for a live hearing where the parties are in separate rooms. You can understand why alleged victims, alleged perpetrators may not want to be in the same room for this process, but it's got to be live, and we've got to have the technology and the training to do that. Additionally, if you have a live hearing, you've got to create an audio or an audio visual recording or transcript and make it available to the parties for inspection or review. After
piling up.
After hearing all that, if you know that there's an avenue to not have a live hearing, let's talk about that avenue to not have a live hearing. So here is what Suzanne and I have come up with as a possibly appropriate course. And now this is going to turn on your state's law about what is required for student discipline and your state's law about what is required for student matters generally. But our thought was having an on-paper process for your decision-making process, which is what the live hearing purpose serves. So after you provide that investigative report to both parties, you then turn it over to the decision maker. You provide each party with the opportunity to submit written, relevant questions that a party wants asked of any party or witness. You then go get those answers, provide those answers to the party that asked them, and actually you provide them to both parties, and then you allow for additional limited follow-up questions from each party. So it's essentially a cross-examination that's on paper. Remember, those evidentiary privileges apply, no invading a legally recognized privilege, the rape shield protections, et cetera, but if you're going to exclude questions, the decision maker needs to explain to the party proposing the question the decision to exclude the question, why it's not relevant, why it's not appropriate. So they are going to have training on that. But it gets you to a place where you can reach your disciplinary sanction without having to have a live hearing, as Suzanne described it.
That's right. So after all this is done, regardless of whether you do it on paper or whether you do it live, you're going to have a written determination. It's going to have to include these elements that you see here. This is not a small list. This is a pretty lengthy written decision. It's not going to be like your one pager you might be used to with a disciplinary hearing. So again, this is a great place for a professional, including us or your board attorney, to assist you with creating a form. And you really need this to be user-friendly and to drive your hearing decision person or your decision person to fill in the blanks correctly, not really blanks, the blocks correctly. And one thing that's required of your hearing decision maker or your decision maker is to make sure they send it to the complainant and the respondent at the same time. That could be email. I don't know that I would put it on the same email, maybe blind copy. That could also be dropping it in the mail at the same time. So it doesn't require that they get there at the same time, just that you send it at the same time. And this becomes the decision unless they appeal. So if they don't appeal, this is the decision. Or if they appeal, this is what is going to be considered on appeal. This is the final decision. Thought you'd never get there. The Title IX coordinator is responsible for making sure that the decision is implemented. So we can't just not follow up. Everything that the decision maker decides has to be implemented. That's the Title IX coordinator's job. And again, no discipline until the appeals are exhausted and the timeline for appeal has expired. So you remember, you may still have them in an emergency removal state, but they're not going to be under any kind of discipline at that time. So remember, their attendance records are going to have to reflect either an excused absence or something that's non-disciplinary during that time if they're out of the school. And of course, you have to offer appeals, including an appeal from the determination regarding responsibility and any dismissals. So whether that's mandatory or permissive, it has to be appealable by both parties, which is really different than what you might be used to. Mandatory grounds for appeal. So these are the minimums basis for appeal that you have to give the complainant and the respondent. Any procedural irregularity, any evidence that wasn't available at the time that has come to light recently. That's sort of interesting. It's not just you didn't consider the evidence that I wanted you to consider. It's, oh, something new has happened. Here, let's reopen the record. And then also the Title IX coordinator or the investigator or the decision maker, someone had a conflict of interest along the way or a bias, and that impacted the decision. And so I should get a new bite of the apple. And of course, you can add another basis for appeal. So if you wanted to say the amount of discipline or some other reason, we wouldn't recommend really piling that on, but the amount of discipline may be one that you want to do just so you can dovetail it with your state processes, which is kind of an advanced move, and you'll need a professional to help you dovetail this Title IX process with your state disciplinary process. Then that would be something you could add to the mix. And the regs really do allow you to do that.
Now, keep in mind that any grounds for appeal that you add on to the basic three need to be equally available for both parties, victim and respondent, claimant and respondent. Here is a suggested appeals process that we have come up with. And keep in mind, this is going to be dependent on your state's law. We think this works with Georgia law regarding student discipline. But, you know, most states have a procedure where if you have more than 10 days of out of school suspension, students can have a local hearing, they can appeal to their local board, they can appeal to their state board, et cetera, et cetera, et cetera. And it seemed incongruous for a Title IX process that could potentially result in a permanent expulsion and a student to not have at least that much of an avenue to challenge the discipline. So what we are considering building out is adding a grounds for appeal for either party to challenge the amount or type of the disciplinary sanction imposed during the grievance process. Consider using your disciplinary hearing process that you're already used to serve only as an appellate Title IX hearing and only for the permissible issues raised in the appeal. So your investigative report, your final report becomes part of the hearing record. We're not there to argue the facts. You're not arguing guilt or innocence. You are only presenting evidence on the issues raised in appeal. And then that disciplinary hearing process can then be pursued to additional levels as part of a usual student discipline process and not as part of your Title IX process. It's complex. We're all figuring it out together. But it seems to be a process that is as efficient as it can be, so you're not running parallel tracks of hearings, but it also provides at least as much due process as is required by the Title IX regulations and as is required by state student discipline due process considerations.
Interestingly. So we feel like that is one of your best options. Again, it is complex and it would have to be set up by a professional. We would be happy to assist you with that. It is very unique, but we think it avoids many of the pitfalls and gives you a lot of the benefits of the flexibility that is built in.
Now, throughout this whole issue, I'm sorry, I skipped a slide, but we've already covered this slide. So throughout this whole grievance process, keep in mind that informal resolution, which has to be completely voluntary, remains an option for you when it involves student-on-student sexual misconduct. It is not available when employees are accused of sexual misconduct. You've got to go through your Title IX process there. But when it's student-on-student conduct, if it is voluntary, students can participate in formal resolution such as mediation instead of a formal grievance process. If, again, I cannot stress this enough, it is voluntary and you've got to obtain their written consent to those informal measures as well. And then one final little burden of Title IX, which is not so little, is a pretty significant record keeping requirement. For 7 years, you've got to retain lots and lots of records regarding your Title IX grievances, as you see in front of you. You've also got to maintain records of any other actions you took such as supportive measures or informal resolutions in response to reports or formal complaints of sexual harassment. Now, record keeping can sound boring and custodial, but it is a very important obligation under the new regs, and it can really cause problems for you if you don't comply with them. And of course, keep an adage in mind, the old adage that if it's not in writing, it didn't happen. So schools need to keep that in mind when they document things like supportive measures or a Title IX coordinator's discussion with a complainant about the supportive measures and the complainant's desires to pursue or not pursue a formal complaint. Now, a primary purpose of these regs is for OCR auditing and investigative purposes, but these records are also going to be a likely target of discovery efforts in private litigation, so keep that in mind. You also do not want to have to keep recreating the wheel every time you respond to one of these document requests, so you want to have an infrastructure in place that enables you to respond thoroughly and efficiently so that the request does not disrupt your school operations. And of course, school districts are document intensive. You all know how to do this, but our team here at Nelson Mullins has a lot of experience in responding to these types of document requests and building out retention procedures that are effective, so we can help you develop those policies and procedures and help you with compliance there. Now, I see that we are 6 minutes over our time.
But that's probably due to my failure. My technological failure at the beginning. So,
well, we thank you for sticking with us. And if there are any questions in the question box, we will certainly get the answers out to all of you. Thank you for sticking with us. If there are any follow-up questions that you have, or if you'd like to discuss any part of this presentation or Title IX, or just a shoulder to cry on
absolutely,
to get ready for August 14th, there's our contact information. Please call or email us anytime. I do want to end on a little note. Both the ACLU and 14 state attorneys general have filed lawsuits trying to block implementation of these regulations. I do not have a lot of optimism that that's going to happen. So we have to proceed as though this becomes a live reality on the ground on August 14th. There's a slight possibility that it won't, but I'm not counting on it. So we hope that you have found this information helpful in navigating what is a very, very complex process. And please feel free to reach out to us and learn more about our education team here at Nelson Mullins.
Absolutely. And we're happy to share with you the slide deck and also the recording of this. If you'd like to email either me or Nina, we're happy to send that to you. And you're welcome to share it in your organization as necessary. Have a wonderful day and good luck out there. Thank you for everything you do for our kids. We cannot say thank you enough for all your hard work.